Private use of cannabis has been decriminalized. Adults can now also grow their own Dagga without the fear of being arrested. Now, there's some confusion as to what this can mean for businesses. Employers may now face some challenges from cannabis-consuming employees. How will they deal with this? Let's speak to Rudy Maritz. He's a legal advisor. He joins us on the line from Cape Town. Rudy, thanks so much for your time. What kind of impact will this ruling have on employers and employees?
Good evening. Yes, it's quite an interesting scenario that we have, in the sense that the original case was based on the issue of use and possession of cannabis at home. In the ruling, that at-home part was removed, and it focused mostly on privacy. Now, basically that means that possession of cannabis is no longer illegal if you use it in private. Now it takes it a little bit further than just the walls of a dwelling. It can be in your garden, it can be on your person. And the problem that we have as employers is that the Occupational Health and Safety Act, under the General Safety Regulation 2A, prohibits us to allow a person entry into the workplace if he is under the influence of alcohol and drugs, and secondly, if he is in possession thereof. Now, that can be given the ruling as it stands, although the Concord did not rule or did not order that specific legislation to be changed. Employers might find it difficult now if they have consuming employees and they want to take disciplinary action against them for possession of cannabis if they have it on their person or in their bags. So employers will have to look at their policy and see how that can be changed so as not to infringe this ruling and also create future problems in terms of disciplinary and labor law.
When we were speaking to Gareth Prince earlier on, who's someone who's been pushing for the decriminalization of Dagga for over 2 decades, he was saying that it's also a way of people being able to make money from marijuana, cannabis. Explain the legalities of that to us, or is that taking it a step too far, as the Constitutional Court hasn't said that you can sell cannabis?
Well, the argument in the Constitutional Court was that dealing in cannabis in terms of the Drugs Act is a little bit of a concern. You're not allowed to sell it, but you cannot purchase it without a sale. And basically what the court said is that they are not going to get involved in that part of the debate, as the High Court, the Western Cape High Court, didn't specifically address that issue in terms of the purchase and selling of cannabis, which basically comes down to the fact that the trading in cannabis is still illegal.
We know that there's 24 months where Parliament has to make amendments to certain legislation in order to give effect to the judgment that was today. So what do employers do in these 24 months with those issues that you raised and the grey areas that may have arisen from that?
Okay, first of all, it's important to note that the 24-month period only applies to certain pieces of legislation that needs to change. And the one that the court ordered them to look at is the Drugs Act and the Medicines Act. I'm just trying to find a reference here in the judgment. But they also touched on Section 22 and Section 40 of the Criminal Procedures Act. Now, in essence, basically what happens is that the court suggested certain amendments and gave Parliament 24 months to do these amendments. Should Parliament then fail to adhere to the order, those amendments in the judgment will become effective as if it was published in the Government Gazette. What is happening in the interim is that they've added some read-in phrases, which means that pending the 24-month period, you need to read the current regulation with the read-in phrases as it was ordered.
Rudy Maritz, thanks so much for your time. A legal advisor joining us on the line there from Cape Town. Let's go